Good afternoon, everyone, and welcome to the Silicon Valley Urban Debate League's fourth Moot Court. My name is Willie Hernandez, and I serve as the board chair for the organization. As many of you watching today know, the Silicon Valley Urban Debate League, or SVUDL as we call it, is a nonprofit organization that enters high schools in underrepresented communities to teach them speech and debate. Now, SVUDL operates on a simple premise, and that is that students from every community have the same skills and potential to succeed. SVUDL's goal is to teach these students how to think critically, weigh evidence, and communicate persuasively. These are the same skills that it gives the students the power to drive their own success in life. Now, our world changed a few months ago when the pandemic hit. As our students were sent home to shelter, I am proud to share that SVUDL pivoted its programming to continue to connect with the students and allow them to continue on their speech and debate journey. Tonight is a celebration of that success. Now, why Moot Court? We know that the skills learned through debate are transferable to almost any professional path. And our students want to pursue a range of career paths. However, nationally, urban debaters report greater than 50% wanting to go to law school and pursue legal careers, which of course makes sense considering they spend their high school years researching, writing briefs, and arguing. So this event shows them how they can transfer their skills into perhaps the most challenging, complex form of advocacy, appellate argument. Now, we wanted to host this argument in person like we have in the past, and I want to thank Mark Fernandez and the entire team at Intuit for all the work they put into planning an in-person event at their headquarters. Hopefully, next year. That said, after several months of sheltering and conducting all forms of business remotely, this seems somewhat normal. In fact, courts are now hearing cases the same way they will hear our argument this afternoon. So before I turn it over to Angel Armento to introduce the case, I want to thank first Dr. Rob Burns for all the work that he put in to helping the students get ready for this argument. I also want to thank Leslie Spencer, Wayne Stacy, Andrew Gold, Nadia Arid, all lawyers, fellow board members, for working with the students to coach them over the past couple months. And of course, special thanks to my good friend, my former high school debate partner, fellow board member, and the person with the original vision for this event, Chris Hersey. I want to thank our judges for joining us to hear the case. From the Ninth Circuit, Judge John Owens and Judge Michelle Friedland, and Justice Mary Greenwood, the presiding justice from the 6th District Court of Appeals. Thank you for your commitment to our students and for investing your time to give them a platform to demonstrate their skills and their advocacy. So tonight, you will see 6 students arguing. From Cristo Rey San Jose Jesuit High School, you will hear Rachel Staton, Sophia Funk, and Mateo Diaz. From Silver Creek High School, Dash Jane and Jasleen Kang, and from Downtown College Prep, Chris McGinnis. And with that, I hope you enjoy the argument, and I will now turn it over to Angel Armento to introduce the case. Thank you very much.
Thank you, Willie. Hello, my name is Angel Armenta, former student attorney at the last Moot Court event, and I'm happy to be back with you all introducing this case that will be argued this afternoon, Russian Nif Studio LC versus the City of Phoenix, a case brought upon the Supreme Court of the state of Arizona being re-argued by SVUDL students in front of you. This case involves 2 young Christian women, Joanna Duca and Brianna Koski, owners of Brush and Nib Studio, a calligraphy art studio in Phoenix, Arizona, which designed custom invitations for all occasions, so be it follow their policies, and a city ordinance from the city of Phoenix used as a countermeasure to eliminate all forms of discrimination in public accommodations. This case will discuss two key First Amendment violations on behalf of the plaintiff. The first violation is that the city ordinance violates the right to freedom of speech by requiring them to make same-sex wedding invitations and at the same time not publish a statement about not selling to same-sex marriage couples. The second violation is that the ordinance violates the right to freedom of religion by endorsing same-sex marriages. Before we begin, on behalf of SVUDL, I would like to thank everyone for being here this afternoon, and I would like to hand it over to Judge Owens of the Ninth Circuit, our presiding judge this afternoon, to call the case and our Zoom video conference to order. Thank you and good luck to everyone.
Thank you, everyone. Thank you, everyone, for being here today. On behalf of my colleagues, Judges Friedland and Justice Greenwood, welcome to the fourth SVUDL Moot Court. I can say this is one of the things I love doing in this job, is getting a chance to work with the students here. Before we begin, I just want to tell the students something to reiterate what Willie Hernandez said. You might think, well, this is too bad. We're doing this remotely. We're not doing this in a courtroom or at the headquarters of Intuit. This is how court is now being done in the federal and state systems. So honestly, you are getting the same experience that lawyers will get. I will tell you, Judge Friedland and I were supposed to be in Hawaii next week for calendar. That did not happen. So we are going to be doing this next Wednesday, Thursday, and Friday of next week. So if anyone is interested in finding out how to do that, you can visit the Ninth Circuit's website and see Judge Friedland and I and another colleague doing this on Zoom, possibly with the same background you see now in other cases. And with that, lawyers, before you start making your appearances, I want to talk to you about timing today. We're going to do it the old-fashioned way. So you're going to have roughly 7 minutes each. I will be the timekeeper. And what I will be doing is I will be giving you a 5-minute warning, which means you have 5 minutes left, a 2-minute warning, and then a 1-minute warning. When I give you the 1-minute warning, it's time to start wrapping up. And with that, I think we're ready to proceed. So counsel normally would say step up to the lectern. Not exactly what we're saying now. So go ahead and turn on your Zoom and we can get started.
Judge Owens, and may it please the court. My name is Jasleen Kang, and with my co-counsel, we represent the appellants, Brianna Koski and Joanna Duca, the owners of Brush and Nib with their case against the city of Phoenix. May I reserve 6 minutes for rebuttal?
Yes.
Thank you, Your Honor. Brianna and Joanna, using Brush and Nib, create handcrafted invitations tailored to their clientele's weddings, each carefully reflecting the messages the customer and the artist desire to represent. This has consistently remained their hope for their business, and they make it clear on their website that due to their devout Christian beliefs, they do not wish to make invitations celebratory of same-sex weddings. However, their protected right of freedom of speech is coming under direct threat from a City of Phoenix ordinance aimed to protect a customer's sexual orientation and other classes. And thus, this case at its core is about two main issues concerning our client's freedom of speech and freedom of religion. These rights under this ordinance are being violated, placing them under direct threat of fines and jail time. Today, I'll be discussing Brianna and Joanna's right to design and create artwork, as well as to publicly post their views on the company's site. To begin, we must first discuss what type of content Brianna and Joanna make. These invitations that Brush and Nib design are incredibly unique. Not only is every single detail and design hand-drawn, but Brianna and Joanna ultimately make use a vast amount of labor over each element, and they make a majority of the artistic choices. And in cases such as Coleman versus the city of Mesa, pure speech was ruled as more than just written or spoken word. It can be media whose main purpose is to express thoughts, emotions, or ideas, and conduct is expressive component.
So I understand that your argument is that their art is expressing celebration and approval of this wedding. But my understanding, at least from their website, is that they have customers who they don't really know. So am I right that, say they have an opposite sex couple whose invitations they're making, they're not looking into whether the future groom is beating up the future wife, and whether they really should be approving of this wedding. I don't think, at least from what their website says. So how can we say that they are really approving of every wedding that they're writing an invitation for?
Well, thank you for the question, Your Honor. And while they, in the beginning, might not know their customers, over time, because they want these invitations to be incredibly personal to the event, they spend time getting to know the customers and getting to know what kind of relationship they have, and ultimately how the wedding is going to be. Therefore, at the end, they would end up finding out a lot of details about the couple and the relationship themselves. And if something is available up front that they know they will personally object to, such as the couple being a same-sex couple, then it is their right in our as our stance to be able to deny making artwork for that event.
So as I understand it, counsel, your argument is that the wedding invitations essentially constitute pure speech, and therefore they are entitled to protection. But if these invitations are pure speech and not conduct, as the city of Phoenix is asserting, why wouldn't a wedding dress, for instance, also fall into the category of pure speech, or for that matter, the food that's being served at the wedding? It seems that those things might more appropriately be deemed conduct, and that similarly the invitations would be conduct. The fact that there simply are brush strokes on a piece of paper does not convert something into an artistic expression. So how do you respond to that?
Well, thank you for the question once again. And we believe that we can inarguably place Brianna and Joanna's art and invitations specifically under this category because of the nature of the way that they are created and the nature of the invitations themselves. They spend a lot of time over each element, over each design. Everything is incredibly hand-drawn and every single detail is looked over. Even the simple message of celebrating the wedding itself is very direct, and they spend time choosing which calligraphy. At the end, this is incredibly artistic and it comes from their heart. This is a representation of what they believe they want this wedding to be and what they believe should represent the wedding itself. And thus, while those other examples are in those other examples, the court can argue over whether that is art or is not art. In this specific scenario, it inarguably is art due to the nature of the final product itself.
Counsel, the government compels speech all the time. You mentioned a lot of time was put in by these two artists into their artwork. I can think of advertising campaigns where thousands of hours are spent to try to push a certain product, Coca-Cola or cigarettes or whatever it might be. And the government requires people to attach speech they don't want to put on it with that message. Why is this different than requiring a chemical manufacturer to say that their paint may have elements that cause cancer, or that cigarettes cause cancer, or the calories on a restaurant menu? Why is this different than that?
Well, thank you for the question. And we believe that those are two incredibly distinct situations, because in that scenario, for example, where a chemical manufacturer may be stopped from making their product, it is not them in this, it's not them in the same way representing a message or creating this sort of artwork that represents any sort of artwork. In this specific scenario, they are creating these designs, and in the end, this will be compelled speech because this is something that's coming directly from the heart. It is directly that type of art. And for them to be forced to design something that they're so personally against then becomes an incredibly painful experience.
If they had a belief that Islam should be prohibited in the United States, they had personal animus against Muslims, could they say that they had a right to turn down any invitation for a Muslim wedding?
Well, we uphold and firmly believe that Brianna and Joanna have no intention to discriminate against the customer or anything of that sort. And in that specific scenario, if they are personally against something or they believe that something is against their religion, then we believe they should have the right to deny creating that custom artwork. However, they will not.
I think you were arguing about speech, right? So let's put aside their religion for a second and just say they believe that Muslims shouldn't be allowed to get married in the United States, and they don't want to speak on these invitations for a Muslim wedding. Would it be compelled speech if the government said, no, you can't discriminate based on the religion of the wedding?
We uphold that would still be compelled speech due to the fact that it's something that they otherwise would not have created. Thus, the government would be forcing them and compelling them to create the final artwork. And it is not them denying against the customer or their status or anything like that. They will happily serve the customer. They simply object to making the message that the customer is requesting them to do so. And they're open to any other generic invitation or product that they have on their website, just simply not that custom product due to the due to the fact that they're personally against what it would represent.
All right, well, look, why don't we go ahead and we'll see you in rebuttal. We'll give you a few minutes for rebuttal. You get a chance to respond to the other side, okay?
Thank you.
Terrific, thank you very much, great job. All right, who's up next?
Judge Owens, and may it please the court, my name is Christopher McGinnis, and I will be representing Joanna Duca and Brianna Koski on the matter of freedom of religion. So the state of Arizona's Free Exercise of Religion Act, or FERA, establishes that no government policy shall substantially burden one's religious belief. The ordinance produced by the city of Phoenix starkly contradicts the fundamental principles under which FERA was established. Legally, there are 3 burdens in which one has to prove to establish a FERA violation. The first 2 are matters of the sincerity of my client's religious beliefs, which have already been established by me and my co-counsel's, by my co-counsel's previous dialogue. These are strongly held religious beliefs by my clients, and there's really not a question on that. Next, the third being is that it is in fact a substantial burden on my client, or the policy creates a substantial burden on my client. The fact that my clients are threatened with hefty monetary fines and jail time proves tremendously that this ordinance offers clear substantial burden to my clients. So on the matter of compelling interest, the city of Phoenix has to prove that there is compelling interest on this matter. And although protecting the citizen's right to marriage is important, we have to keep in mind that by infringing on Brianna and Joanna's religious beliefs, this court will be setting a dangerous precedent. And the city of Phoenix has the burden to prove that this is the best and the most direct way to solve for this discrimination, a feat that they simply can't accomplish. They have to prove that, you know, this is the most, this is the best way to accomplish that feat, and the most restricted way, right? That there isn't a way that we can go about this law.
So I think you're arguing that the city is violating your client's religious rights, but I'm wondering why they have to be in the wedding invitation business. Why isn't it okay for Phoenix to say, if you want our police and our fire protection and the safety of our roads, and you want a business in our town, and you want it to be a wedding invitation business, then you have to give wedding invitations to anyone. And if you don't want to be in the wedding invitation business, no one's going to force you to. So you can have whatever religion you want, but you can't do both.
That's one of our points, Your Honor, and thank you for the question. The matter is that my clients produce other invitations, right? They produce standard invitations and pre-made invitations that they would be happy to sell to any client. The question comes when my clients are producing specific artwork. They're sitting down with the clients, and they're talking to them. They're getting to know them, and with that, they're putting in the work to produce this artwork, and that's the question. And I feel that although, yes, some may feel that the city of Phoenix should have the right to, say that you're in the business, so you should do it. I think that that's extremely problematic, right? I think we really need to think about this in the way of, we are forcing, if we force anyone to disregard their strongly held religious beliefs, is that okay? And I don't believe that's true, right? And even though, yes, they chose to be in the business, they also, they also choose to follow their religion, right? And they still have protected religious beliefs. So with that being said, I think it would be extremely problematic to force them to disregard those religious beliefs, even though they choose to be in the business that they're in.
So one of the points in your argument is that this is excessively burdensome. This ordinance imposes a burden on your clients, but why is it burdensome to expect an American business to sit down with people who have divergent views and to provide a service for them? essentially. I mean, the fact that they write the word celebration does not mean that they are endorsing the marriage. It simply means that they're providing an invitation service, a product really, for these people who want to get married. So why is that burdensome on their religious freedom?
Right, so it's a burden on their religious freedom for multiple reasons, but the main reason is that, you know, yes, one may feel that they should have to accommodate every single person that comes in. Once again, they're attempting to accommodate as much as they can. The only thing that they feel that they shouldn't have to do is disregard their religious beliefs, and that is protected for them under FARA, or the Free Exercise of Religion Act. So although this is true, we shouldn't, it's extremely burdensome because we're forcing them to disregard their religious beliefs. And although they should be, although it's true that they're, you know, that as Americans, right, there's many types of religions and many types of people in the country, we should, I think it's, the main question is that the main matter is that we should keep their religious beliefs and let them follow their religious beliefs. And by forcing this law upon them, we would be forcing them not to do that, right?
Well, counsel, let me follow up with that, because we put all kinds of limits on religion. And you think about right now, if in California, if you want to have 800 people in a church because of COVID, you can't do that. The fire codes apply to churches. Churches have to respect the employment laws, et cetera. So there are limits placed on religion. Why is this that much worse than telling a church, look, you can't have 800 people at your sermon this Sunday. You can only have 100. Why is this worse than that?
Right. So as I expressed earlier, it's a matter of compelling interest. And we feel that the city of Phoenix can't prove that there is enough compelling interest to force them to disregard their religious beliefs, right? So it's determined that there is enough compelling interest to force churches to follow the fire code, right? But in this case, we feel that there isn't enough compelling interest, and that by forcing Brianna and Joanna to disregard their religious beliefs, that will create enough change, and that there is enough compelling interest in that specifically.
But isn't preventing discrimination a compelling interest? I mean, what if all businesses decided that they had religious beliefs against serving African Americans? Would that be okay? Wouldn't there be a compelling interest in saying that that's not a reason to not serve those clients?
Right, and we would ask that the court, you know, hears that on a case-by-case basis, right? So the difference between that is that this is more that the religious matter and the speech matter become hand in hand, right? It's a matter of religion, and that the argument is about religion. And I feel that with the argument about serving an African-American couple, I think that that's an extremely different argument being made.
Okay, Mr. McGinnis, thank you for your argument. If you have just a closing sentence you want to make, feel free to make it now.
To conclude, Your Honors, on the matter of freedom of religion, the violation is clear. The City of Phoenix Ordinance starkly violates not only FARA, but my client's constitutional rights to the freedom of religion. We feel that there is not enough compelling interest to rule in favor of this law. Thank you.
Thank you very much, counsel. Okay, counsel, you are, just go ahead and make your appearance and state who you're representing, and you can proceed. Oh.
Good evening, Judge Owens, and may it please the court. My name is Rachel Staton, and along with my co-counsel, we represent this community and the people of the city of Phoenix. Before we begin, I would like to reserve 6 minutes for rebuttal.
Okay.
Thank you, Your Honor. Your Honors, the question we would like to address today is whether or not the Equality Ordinance passed by the City of Phoenix to protect citizens from discriminatory conduct from public accommodations intrinsically infringes upon the protected speech of business owners or the freedom of speech of business owners who refuse to sell public goods to customers based on their sexual orientation. We represent the City of Phoenix, and the other side claims that this law is violating their freedom of speech. However, freedom of speech is not absolute. People who choose to participate in the public economy do not have the right to do and say whatever they choose. The First Amendment protects freedom of speech, but it is necessary to understand whether or not the ordinance is infringing upon the protected speech of the owners or is regulating the discriminatory conduct not protected by the First Amendment. Even if it is the case that the ordinance is restricting the appellant's speech, this kind of restriction is acceptable should there be compelling state interest in restricting this type of speech. There are two reasons why the ordinance in question is necessary and does not infringe on the speech of the owners. The first is that the Equality Ordinance regulates conduct rather than speech. The services provided by a public accommodation should be equally distributed to all customers, regardless of sexual orientation. In this case, Brush and Nib decided to make custom invitations for weddings, a service open to the public, and the ordinance only requires them to provide that service to individuals on a non-discriminatory basis. Brush and Nib are not practicing free speech by attempting to deny service to customers based on sexual orientation. That is action and conduct by a public accommodation that is discriminatory in practice. The ordinance itself is content neutral, and any product that is being made publicly available should be done so, again, on a non-discriminatory basis. This is not about the message they post on their website. Brush and Nib is allowed to express their beliefs on their webpage, stating that they believe marriage should be between a man and a woman. The only issue is when they attempt to reject customers requesting a message for their own same-sex marriage. The Equality Ordinance does not infringe upon their speech. However, the services being offered by a public accommodation cannot be denied to certain customers based on their sexual orientation. Next.
If there's a customer who wants a same-sex wedding invitation from this business, why would they still want it if the artists are basically saying we don't want to make it? Wouldn't the artists do a bad job making the art if they're not feeling like they're comfortable doing their art? At that point, I'm not sure why you would want that invitation.
Thank you for your question, Your Honor. We believe that would be the prerogative of the client or the customer themselves. However, the fact of the matter is that businesses who serve the public or offer public goods and services should still be willing to provide all public goods and services to every customer, regardless of race, nationality, religion, or sexual orientation. So that being the case, the ordinance is only attempting to regulate that conduct that business has when distributing those products to the public. On my next point, there is no way to make this ordinance any narrower than it currently is. Truly, the only way to stop discrimination is by saying you can't discriminate, not to make exceptions on who can and can't discriminate. Those exceptions based on freedom of speech would be reminiscent of Jim Crow era signs outside of public accommodations refusing to sell to people of color. We would argue that while there is no need for the highest standard of review since the Equality Ordinance truly only regulates conduct, there would still be compelling state interest to uphold the Equality Ordinance in favor of preventing discrimination against marginalized groups by businesses like Brush and Nib. The free speech of Brush and Nib is not being targeted here. However, the way the plaintiffs wish to pick and choose their customers based on sexual orientation rather than the content customers are requesting is discriminatory conduct that is not protected by law.
Could we agree with you without overturning our precedent about tattoos?
I apologize. Could you refrain your question?
Yeah, so I believe we have case law saying that tattooing is expression. So I'm wondering if we would have to get rid of that precedent to agree with you, or whether there's some difference between art on invitations and art on tattoos.
Thank you for your question, Your Honor. While we agree that there are some expressive means of displaying the message that the customers are requesting here, we still believe that that speech is that of the customer rather than that of Brush and Nib themselves. Brush and Nib, the artistic component of Brush and Nib is only the way they write the customer's message, not the fact that they write the message itself. So in our opinion, we would believe that in this specific case, it would still be considered a public good and conduct by a business to refrain from selling that, from offering those services to certain customers or certain clients based on their sexual orientation.
So what if instead of declining to provide this service to someone based on sexual orientation, let's just assume for the moment that this is art, that it is speech, and what if the Brush and Nib were required to provide this to someone who wanted them to express something very offensive in the wedding invitation, something racist or something against some other religion, as Judge Friedland had mentioned, an anti-Muslim sentiment, or you know, an invitation that excluded particular people. Would they have the right to refuse to provide that type of invitation and to provide that service?
Thank you for your question, Your Honor. And the answer to that shortly is 100%. The discrimination only comes in when, based on the identity of the person requesting the message, they refuse to provide that service. So if the message, for example, is saying, we hate Mexicans, they are legally allowed to say, no, well, like, we don't want to provide that message. However, when it comes to things like, we want to request a message for our wedding as you provide to every heterosexual couple, that's when it becomes discrimination because they're refraining from doing so solely because of their sexual orientation.
So if somebody with a particular religious belief, so for instance, let's assume for the moment that there were a religion that believed in the subjugation of women and they wanted that expressed, that sentiment expressed on the wedding invitation, even though it's a religious group who's making the request, would it be your position that Brush and Nib would be able to say, no, we're not going to provide that to you?
Thank you for your question, Your Honor. If Brush or Nib was already providing that service to other customers, a lot like writing that women should be subjugated on other cards for heterosexual couples or for other Christian couples, then it'd be a matter of discrimination if they refuse to write that message on a card for simply based on that person's religion. However, again, as I mentioned before, they provide wedding invitations to heterosexual couples, custom wedding invitations to heterosexual couples, and are solely refusing to do so for homosexual couples based solely on their orientation. That's when it becomes a matter of discrimination rather than a matter of a message.
Look, we are running out of time, so I'm going to ask a question, but ask you to think about it and answer it in rebuttal when you get a chance. Give me other examples of when we can compel someone to write something that they don't want to write. Okay, so that's the question for you. But we are almost out of time, so if you want to wrap up your talk, and we'll hit you and you have a chance to do rebuttal. Go ahead.
Thank you. By regulating how Brush and Nib provide their goods and services, the ordinance protects marginalized populations from discrimination. While we recognize the artistic components of Brush and Nib's products, we vehemently request that the courts uphold the anti-discrimination ordinance to protect same-sex couples and other protected groups from unfair discriminatory conduct from public accommodations. Thank you, Your Honors.
Thank you, counsel. Mr. Diaz, you may proceed.
Judge Owens, and may it please the court. My name is Mateo Diaz. The second critical issue before the court this evening is whether, under the First Amendment and the Arizona Free Exercise of Religion Act, may the appellants who choose to sell their products to the public nevertheless discriminate by refusing to sell wedding invitations for same-sex marriages because of subjectively held religious belief that disapproves of gay weddings. In State v. Hardesty, the Arizona Supreme Court set forth a clear test for when individuals may claim violation of their rights to the free exercise of religion. The appellants have the burden of proving all three of the following. First, their decision to discriminate against same-sex couples is motivated by their religious beliefs. Second, those religious beliefs are sincerely held. And most importantly, third, the ordinance in question, which requires equal treatment of all customers regardless of their sexual orientation, must substantially burden the exercise of those sincere religious beliefs. Even if the appellants make the initial showing, the City of Phoenix is justified in keeping its anti-discrimination ordinance if the city has a compelling state interest. In this case, we strongly condemn that the Arizona FURA law does not entitle the appellants to discriminate against same-sex couples based on their religious beliefs, regardless of how sincere they may be. Here, not only have the appellants failed to meet the three-part test established by the Hardesty Court, but they cannot overcome the compelling state interest that the City of Phoenix has in outlawing discrimination. For my first point on FURA, there is no substantial burden for the business. The business will still sell pre-made items to anyone, showing that the business is fine serving anyone, even same-sex couples, proving that there is no government burden, but also there is nothing from them that states that their religion requires them to cater to certain people and forbids them from selling to certain groups.
Mr. Diaz, if I may jump in real quick, under your understanding of how this Arizona, or your theory of the case, I would say, if a consumer were to say, look, if I go into a store, this store, for example, and it makes me feel very uncomfortable to know that there's a lot of signs of Christianity in the store. For example, there's a cross on the wall, or the people who run the store wear crosses, a Christian cross around their neck. And it makes them feel uncomfortable, makes them feel discriminated against because they're not Christian. Under the state's theory of the case here, could the Phoenix step in and say, we're not going to do anything to make someone feel uncomfortable if they're discriminated against, therefore stores are not allowed to display religious items at all inside?
Thank you for your question. We would say that that wouldn't be, there would be no sense of saying that you cannot wear your religious items or display them in your store, because that is your expression of your religion. But if you are using those religious items to mock and attack people who are from the LGBT community, that'd be a different story. But since they are simply using their religious items to express their religion, there's no issue with that.
So if I can ask you another question, Mr. Diaz, one of the things that we noticed about this ordinance is that it's a criminal ordinance. In other words, fines can be imposed if somebody violates it, brush and nub, for instance, or brush and nib, or somebody could even go to jail. So one of the things that we're looking at that you've talked about is whether the ordinance is reasonable, or and I'm wondering what you have to say about the reasonableness of using a criminal method of enforcing this anti-discrimination policy, as opposed to maybe, telling people that their license could be pulled or something. Isn't there a problem with putting people in jail?
Thank you for your question. Sorry. I would say that the ordinance itself is there to prevent discrimination, and the way the law is enforced is to help tell people not to discriminate, but also that they have not been charged with anything. They have not broken the law, and they are, as they do, they are fine selling pre-made items to customers, so even to same-sex couples. So there should not be any issue with them with the law. For my second point, the great state of Arizona has a great deal of interest in the anti-discrimination ordinance. Over the years, she has made wonderful strides ensuring that every person is protected and not discriminated against. This protects everyone. If the law is reversed, it would lead to decades of work to be undone, and discrimination claims will be what defines the new era of Arizona. Also, we should not have the anti-discrimination law be revoked for a single business, as the anti-discrimination law right now is protecting thousands, maybe even tens or hundreds of thousands of people. In conclusion, the court should uphold the anti-discrimination ordinance, and the court should reject the religious-based claims. They have failed the three-part test, and the City of Phoenix has a compelling state interest in preventing discrimination. No one in the great state of Arizona should ever be discriminated against because every voice matters.
Thank you very much, Mr. Diaz. I believe now we're going to move on to rebuttal. So each side has rebuttal. I'm going to give each side 6 minutes for rebuttal, and then it's up to the lawyers to make sure they don't run over each other. It's one of the things we see in the Ninth Circuit all the time. I'm sure you see it in the Court of Appeal where lawyers split time and one lawyer takes all the time, the other lawyer has 15 seconds left. So we're going to hold you guys to that. This is a good drill for that. So if we could have the first counsel appear again.
Sorry, Judge Owens, if I'm not mistaken, we have separate rebuttalists rather than...
Oh, I apologize. All right, so 6 minutes. Okay, so just so we're clear, thank you for appearing. So you have 6 minutes, okay? Are you splitting the time with anybody or is it just you?
It's just me.
All right, you got 6 minutes. Actually, I'll give you, because it's just you, I'm gonna give you 7 minutes. All right, take it away.
Judge Owens, and may it please the court. My name is Zux Jain, and today with my co-counsel, I believe that we've conclusively proven that the city has not demonstrated enough compelling state interest in the continuation of the City of Phoenix's Human Relations Ordinance. The very ordinance that could force our clients, the appellants, Brianna and Joanna of Brush and Nib, to put their names on a message that goes against a fundamental tenet of their religion, while also suppressing these very same values. The issues that our clients raise with the ordinance can be isolated as a violation of their freedom of speech and freedom of religion, two of the most essential rights guaranteed to those in the United States. Our argument surrounding freedom of speech can be summarized as such. Despite the City of Phoenix's attempts to mitigate the significance of our clients' products, the custom invitations, which are specifically all that our clients are defending here today, should be regarded as pure speech. Unlike the other products that they sell, the custom invitations require near complete creative liberty from Brianna and Joanna and are specifically tailored to the event that they are for. It's not a fungible product that our client is refusing to sell, but rather their own voice. In fact, the record shows that our clients have never refused to sell products to same-sex couples. The issue solely lies with the creation of these custom wedding invitations for them.
So if I can just ask this though, it's a wedding invitation. So you're saying pure speech, but I'm troubled by the idea that the wedding invitation doesn't belong and is not being issued by your clients. The wedding invitation is being sent by the couple to the people who are meaningful to them to attend their wedding. So it's difficult I'm wondering how that fits in with the idea of pure speech. In other words, really, isn't this a service?
Thank you for the question, Your Honor. And I would say I have 2 points on this. The first is that regardless of whether or not we're going to be characterizing this as pure speech, it is still the speech that we can agree it is speech because art is in fact speech. It is being compelled out of our clients. They would not be creating these custom wedding invitations if it were not for the City of Phoenix Ordinance. But moreover, it should be regarded as pure speech simply because there is some inherent value to the type of artistic representation that our client is adding to these wedding invitations. Otherwise, they wouldn't be commissioned to do so. By getting to know the client and making an intimate message and making artwork that's separate from the textual basis that is being commissioned by them, the artwork itself that is on the invitation is in fact speech, in our opinion.
But counsel, go ahead, Judge Friedland.
I think you argued, and your co-counsel, I think, argued that there isn't really discrimination against gay customers. It's just this message that they're concerned about. But I don't really understand that because it seems like, I guess what you mean by that may be that if someone has a gay wedding planner who actually goes into the store, they're not going to discriminate against the wedding planner as long as it's a opposite sex couple that the invitation is for. But at that point, the wedding planner is just an agent for the couple, and it's the couple whose invitation it is. I think this is what Justice Greenwood was getting at. So aren't they discriminating against the couple at that point? And isn't that discrimination against the sexual orientation of the couple?
Thank you for the question, Your Honor. And so our opponent specifically said that it's a matter of whether or not the discrimination or what messages they're refusing to state are being equally applied to different people. So for example, if a straight couple comes in and requests a message or a wedding invitation for a same-sex couple, they would refuse that. It's not the specific people who are requesting the message that are being discriminated against. It's rather that they don't believe that this form of marriage is a legitimate type of marriage, and thus they don't want to express views that support it.
So what if they didn't believe in interfaith marriage? And so they said, you know, somebody who is wants to be married, who is Jewish, wants to marry somebody who's Catholic, which might not be a commonly held view now, but was, you know, some decades ago. That would be okay because it's not directed against their religious beliefs.
I'm sorry, could you rephrase the question?
Well, I think what I'm really just asking is you're saying it's not directed against the individuals. You're not discriminating against same-sex. They are not discriminating against same-sex couples, but it's difficult to parse that out when basically they're saying those are the only people who are not going to be able to get their art.
Thank you for the question, Nara. So essentially what we're just trying to say, it's not a matter of the person's sexual orientation, because if it was, then our clients would refuse to sell these pre-made wedding invitations that they already have in the store. It's a matter of they don't want to create specific speech for this message, the message of the marriage, not necessarily of the people, but they don't want to support the message that a same-sex marriage includes.
And if they didn't believe that it was okay for Jewish people to marry Catholic people, then they could refuse that invitation as well?
In cases in which the state cannot prove compelling interest, then yes, the clients would be able to discriminate in that case.
I guess, counsel, I think one concern that people would have with your position is that, you know, the nature of our country is give and take. And sometimes you have to do things you might not really want to do for things to work. The Civil Rights Act essentially is based on that a lot. Yes, there's a whole Commerce Clause behind it, but basically saying, look, for our country to move on, we've got to work together. This seems to be a step in the wrong direction. This seems to be a step saying, no, you don't. You can start making exceptions to that rule. And so where does this end? Getting back to, I think the questions of both my colleagues in this case, where does this end? What's the next case that we have to be worried about? Someone who doesn't like interracial marriage. It's against my view of Christianity to have African Americans marrying Caucasians. Therefore, I'm not going to serve that couple who walks in. Tell us where that line is so we can feel comfortable with your position that it's really this case and not a huge change in our law.
All right, so first I would like to point out that there are already many cases in which we already make exceptions. We have instances such as Christian schools that are allowed to hire based off their religious beliefs. And we have other cases that the Supreme Court has seen, such as Hobby Lobby versus the Supreme Court, where their religious beliefs were able to impact a change in the application of Obamacare. So there already are exceptions. And specifically, all we would like to say is that in those other cases that you might see later on as a result of this case, if the state can prove a compelling state interest and that they are the most narrow way to achieve that compelling state interest, then yes, the state should be able to apply those laws. However, the state has done neither of those two things. They have not proven that they are the most narrow. They have not proven a substantial state interest that overrides my client's right to freedom of speech and freedom of religion.
You have about 40 seconds if you want to wrap up.
In conclusion, today we look to a singular nexus question. Do artists have control over their speech, and particularly those that relate to their own religious beliefs? Because at the end of the day, that's all this case is. Our clients never denied service to any individuals based off their sexuality, but rather opposed to put their names on a message that goes against a fundamental tenet of their religion. As it stands, they face jail time, fines simply for following their religion, and due to the state's failure to prove compelling state interest in the law, our clients' right to freedom of speech and freedom of religion are of the utmost importance in today's decision.
Thank you very much, counsel. And finally, to wrap up, Sophia. All right, yes, Sophia, we see you. Ms. Funk, we see you. Go ahead and make your appearance and you may proceed.
Good afternoon, Judge Owens, and may it please the court. My name is Sophia Samano-Funk. As counsel for the City of Phoenix, I will be summarizing today's two most important issues in rebuttal. We've heard the argument from the appellants that making custom wedding invitations for gay couples violates their freedom of speech. This framing assumes that performing a transaction is an exercise of a business's speech. However, the appellant's personal views are irrelevant here, as the Anti-Discrimination Ordinance regulates conduct. As decided in Rumsfeld versus the Forum for Academic and Institutional Rights, there is a distinction between speech and conduct. Brush and Nib operate a business serving the public. The act of selling goods and services falls under conduct, not expression. As a public accommodation, they must offer their products to all paying clients without discriminating based on a protected class such as race, gender, or sexual orientation. Brush and Nib must create and sell custom wedding invitations to any couple regardless of their personal beliefs. Therefore, the anti-discrimination ordinance does not violate the appellant's freedom of speech. We've also heard the appellants make the argument that they may discriminate against same-sex couples based on subjective religious beliefs. But the City of Phoenix still has a compelling state interest to prevent discrimination against some of the most marginalized members of its community. Even if the appellants can prove that their refusal is motivated by a religious belief, that their beliefs are sincerely held, and that the ordinance burdens their free exercise of belief, they have not disproven that there is a compelling state interest to prevent discrimination. The government has the responsibility to ensure equal access to businesses and services for its citizens. The state cannot meet this goal by allowing discriminatory exemptions based on arbitrary beliefs. Allowing Brush and Nib to refuse services to same-sex couples and publicly advertise their discriminatory practices creates an unsafe and unequal environment for the LGBT+ community.
When you say arbitrary beliefs, are you questioning whether these beliefs are sincerely held?
Thank you for your question, Your Honor. In this case, we are not going to make the argument, we're not going to go there and say that their beliefs are not sincerely held, precisely because it's very difficult to actually figure out what is a sincerely held belief and what is not. So we're not going to make that argument today. When I say arbitrary beliefs, I mean anyone can basically say anything behind the shield of religion, say this verse of the Bible or this verse of the Quran says this belief and that's why I believe it. The court should not allow businesses to get a free pass to discriminate while hiding behind the shield of religion.
So what if instead of this particular business, we were talking about a commissioned artist, maybe even a famous commissioned artist, and let's assume that that commissioned artist had strongly held religious beliefs that did not support same-sex marriage or did not support interracial marriage or whatever, and they were approached to do a commissioned artwork for a very large gala, to Hollywood artists or something, and they said no. In this instance, in that instance, would you take the same position that the artist would have no right to refuse?
Thank you for your question, Your Honor. In this case, the ordinance is focusing specifically on public accommodations. If you're referring to an artist who, for example, does most of their work, they do their work and they sell pieces to galleries, but they do not open their artwork to the general public just to commission for anyone to commission. In that case, the ordinance would not concern that situation. But in the situation that an artist is open to the public, they are, for example, they have a Redbubble or an Instagram where they are commissioning artwork, or people in the public can commission artwork. We would say that they must provide their services to all paying clients, regardless of their sexual orientation or race or backgrounds.
So counsel, there are these self-publishing businesses, for example, where you can, if you don't have Random House behind you or Doubleday, you can pay a company to publish a book. And often they are faith-based. There are all kinds of Christian publication firms. Under the Arizona law, would a Christian-based publication firm have to be required to publish a book that, for example, was considered heretical to the Christian faith, saying that Jesus Christ was an axe murderer or something like that? Would they be required to, under your view of the law?
Thank you for your question, Your Honor. If it were in this situation, first I'd like to say that it's distinguishable from the fact pattern at hand. But even so, if it were just a publishing house that is not affiliated with, for example, the Catholic Church or the church in general, and it's just Christians at the head of this publishing house, then we would say that yes, they would have to publish. They could make decisions based on, we don't think that this is a good book, based on like the plot doesn't make sense and the characters are poorly formed, but they would not be able to reject an author or an aspiring author to be published just because, well, you're gay, so we're not going to publish your book.
Well, I think that the issue here is not that the identity of the person, as I understand the argument from Brush and Nib, it's the message being conveyed is one they're not comfortable with. And so kind of getting back to the question I had for your colleague, can you think of another situation where government can compel someone, in a sense, forced expression, not merely a warning about chemicals and things like that, but actually forced expression of an idea? Any other things you can point us to so we can feel more comfortable with Arizona's position in this case?
Thank you for your question, Your Honor. To answer this question, one example that I can think of would be businesses who do not want to post a sign on their doors saying masks are required for entry. I understand in California, it is masks are not required in public places. And there may be, for example, a business owner who believes that the pandemic is a hoax and that they don't believe in masks and they don't think that they work. However, the state could compel them to post that sign on their storefront because there is a compelling state interest to do so. In this case, there's a public health reason to do so. In this case, and in the case at hand today, there is an interest in preventing discrimination. And also to answer a previous, or do you have another question? I'm sorry.
No.
Oh, sorry. To answer a previous statement made, we do understand that it is their public position that they will sell to anybody and provide invitations to anybody. But the appellants very simply are refusing to sell custom wedding invitations to gay couples. They're refusing to provide a service to gay couples that they would otherwise provide to straight couples. So it's not, even though it's their public position that, oh, we're not going to reject you because you're gay, in practice, that's what they're doing.
All right, counsel, if you want to wrap up.
Yes, thank you. To conclude, the court should protect the rights of the LGBT plus community in Phoenix by upholding the equality ordinance. The appellants have failed to prove how a transaction between a business and a client is a forced expression of belief. And moreover, the city of Phoenix has a compelling state interest to prevent discrimination in all of its forms. So with that, Your Honors, we urge you to dismiss the appeal and uphold the equality ordinance. Thank you.
Thank you very much, counsel, and I believe this matter is submitted. And I just want to say on behalf of my colleagues, we'll all say something here in a moment, but I just want a little applause here. I know you can do the little applause on the little Zoom thing, but I actually I'll do it for real. Willie, would this be a good time for me to make some comments as well as my colleagues?
Yes, please.
Great. Well, if we could call up all the students who argued so I can see them. There we go. There we go. And thank you for correcting me on the rebuttal. When we're in court, we can see everybody. That's one of the challenges to Zoom, where we don't know who's coming up next. It's kind of exciting, you know, because all of a sudden another face appears. But that's one of the things as judges we do. I say this every time, and I'm going to say it again this year. I wish the lawyers that appeared before us were as good as you are. And I wish that they were as prepared as you are. I really mean that. I have a great job. All the judges on this panel have a great job. But it does get frustrating when you have lawyers come up who clearly are not prepared and don't have the passion for the job. That gets old. You guys, there's never a shortage of passion. There's never a shortage of preparation. It's just really refreshing. I could do these all day. Bad lawyers before you, it's hard to do 2 or 3. I want to get out of there. But with you guys, I could do it all day because you guys really, really do a really good job. And so I'm just so proud. I'm so proud of all of you and so proud of the program because every year you guys keep bringing it. Having grown up in the Bay Area, having done debate in San Jose with my classmates, Chris Hersey and Willie Hernandez. I remember them in high school when they were your guys' age. It's really great to see that they have continued this. And you guys would have probably beaten us back in high school. It's hard for me to say, but I think you guys probably would have. With that, I'll turn it over Judge Friedland, Judge Greenwood, go for it.
I can jump in and just say congratulations to all of you. You were spectacular. You did a really, really fantastic job. I agree with everything Judge Owens said. I would add, I think maybe we have some of your parents or relatives or others watching, and I would just add if they have never done this before, it is quite difficult to do what you just saw these amazing students do. They made it look very elegant and easy, but actually answering questions on the spot is very difficult. It's hard to listen to the question and think about what you're going to say and answer right away. And all of you stayed very calm. You listened to the question. You answered it as well as you could. You did things that are very, very hard to do. And it's quite impressive that you're doing this at high school. And I am so thrilled to see what you all do next, because I am totally confident that you have amazing futures ahead.
I would also say that the particular question that you had to answer today, that the issues that were before you are really hard, and not just for judges, but for all of us as a society. Where does one right end and another one overlap, and which one gets priority? And there are a lot of really smart people working on these things who do not agree in any type of way, as you could see, you know, from the things that you read. You handled all of that beautifully, including our testy questions. We are experiencing right now some of what happens when you have remote work going on, which is, I have 2 dogs, and they're at the moment, they're having fun, but they're rolling around in the back. And that was the squeal you heard as well. Our 13-week-old puppy, squeak, squeak. So anyway, you all did a really wonderful job fielding our questions. And I'm also just going to say, for your benefit and for your folks, that doing this type of program really can be transformative. I myself was extremely shy when I was young, so shy I couldn't order in a restaurant. And I did what you're doing now. I did debate and public speaking and became a trial lawyer, and then a judge, and now I'm on the Court of Appeal. Now, not everybody wants to do that, but the point is, it causes you to believe that you can do things, and you can. Based on this, if you can face the 3 of us, you can face anyone, by the way. So you did a wonderful job. Thanks so much for letting me participate. This is the first time I've been here, and I'm thrilled to be here. Thank you.
Well, look, last thing I'll say is this, and I think Roland, I think you wants to make some comments, is that the ability to get up and talk intelligently is so valuable. No matter what you end up doing, you're a manager at a restaurant, you're a lawyer at a big law firm, you're a coach of a basketball team, no matter what, being able to speak without going and we see politicians today who can't talk. They cannot string sentences together. So having this skill, no matter what you end up doing, whether you go to law school or not, is invaluable, no matter what you end up doing. So really, this program is so important, not just because we're going to have future lawyers, because we need future leaders. And no matter what it is, you have to be able to communicate. You could be the smartest person in the room, and if you can't communicate it, doesn't do us a lot of good. So great job. Keep working hard. And like I said, I know everyone wanted this to be in person, but I will say this, even once we finally get past this COVID, and I don't have the answer to when that's going to happen, but someday we will, don't be surprised if this is how we do it going forward. Because I will tell you, for Judge Friedland and myself on the Ninth Circuit, back in the old days, before this happened, we were on the road about 40 days out of the year. All right, that's a lot. That's a lot of days to be gone. And I could see a lot of employers, a lot of businesses, and a lot of people who fund our court saying, well, if it works well with Zoom, just keep doing this. You don't have to travel to San Francisco, Pasadena, and so forth. So this is a lot of lawyers would die to have this opportunity to do a moot court like this before judges, because they're not as comfortable with the technology as you all proved today. So really a terrific job. Roland, did you want to come on now?
I did. Thank you so much, Judge Owens.
Sure.
Good afternoon, everyone. My name is Roland Nairo. I am the Executive Director of the Silicon Valley Urban Debate League. Thank you all for spending part of your afternoon with us today. Again, I want to share a special thanks with our judges, Judge Owens, Judge Freeland, and Justice Greenwood. Thank you for presiding today and for challenging our students to think critically and nimbly as they argued and unpacked today's case. Thank you so much to our students, Angel Armenta, Mateo Diaz, Sophia Funk, Dash Jane, Christopher McGinnis, Jasleen Kang, and Rachel Staten. Thank you to your families as well for supporting you all along the way. You all put in so much time and effort to prepare for this event, and it truly showed today. Thank you to our staff, most especially Dr. Burns in helping the students, and also to Corjo Moore and Manuel for doing all the behind the scenes stuff to make something like this happen. Thank you to our board of directors, Willie Hernandez and Chris Hershey, as you've heard their names before, in prepping our students, and also Wayne Stacy, Leslie Spencer, Andrew Gold, and Nadia Reed in helping prep them as well. Thank you to our legal advisory committee for their continued support of our students through our professional access and mentoring program, and for helping to get the word out and invite many of you to this event today. Thank you. We would love your continued support by inviting you to learn more about our organization and volunteering to judge or watch one of our upcoming speech and debate tournaments. So the entire upcoming school year, debaters across the country will be diving deeply into the topic of criminal justice reform, and it couldn't come at a better time. I, for one, look forward to learning from these young leaders of today and tomorrow as they present ideas, arguments, and policies on how to improve systems of policing, sentencing, and forensics in our country. So I invite you all to join me. Thank you all and have a wonderful evening. Take care.